Hello, and welcome to session 2 of our webinar series regarding the COBRA Subsidy provisions of the American Rescue Plan Act, affectionately known as ARPA. My name is Laura Ryan, and my colleague David Uhlendorff and I will be presenting the material for today's program. David and I are both attorneys in the Employee Benefits and Executive Compensation Group here at Thompson Hine. Session 1 of this series, which we presented on April 15th, provided an overview of ARPA's COBRA premium subsidy provisions, as well as the DOL's guidance and model forms that were issued in early April. Today, our focus will be on the long-awaited guidance issued by the IRS last Tuesday. We encourage you to put your questions in the questions box located on the right-hand side of the GoToWebinar screen. We will try to address questions as we go. We will certainly leave time at the end to answer questions. And depending on the number of questions, we may stick around until about 15 minutes past the hour and continue to try to answer as many questions as we can. We will be sending the slides for today's presentation as well as a recorded session within the next couple of days. So be looking out in your email for that. Thank you for attending today's program, and now I'll turn it over to David to kick off the presentation.
Thanks, Laura, and thank you all for joining us this afternoon. We hope you find our presentation informative, and hopefully we'll identify some major issues and resolve some serious questions that have been out there since the legislation was originally passed and since the DOL guidance last month that Laura referenced. So with that being said, today's agenda, we are going to spend the first portion of today's presentation kind of level setting, refamiliarizing ourselves with COBRA subsidy provisions of the American Rescue Plan Act, ARPA. It's been a bit since we've talked about this topic, even though I know it's been at the front of everyone's minds, but it's been a month or so since we've kind of talked about it and had other guidance to discuss. So we're going to level set for the first portion, and then we're going to dive into the new guidance, IRS Notice 2021-31. We're going to highlight some what we think, in our view, are the most impactful provisions of that guidance. We'll identify some next steps and issues for everyone to consider. And then, as Laura said, we're going to get to some Q&As, as many as we can, because I know there are a lot of questions out there. Without further ado, the ARPA COBRA subsidy overview. As most of us, if not all of us, know, ARPA provides a full COBRA subsidy from April 1st, 2021 through September 30th, 2021 for assistance eligible individuals, or AEIs. This applies to all group health plans. In ARPA, it's defined as to include medical, dental, vision, HRA plans. It does not include medical FSA plans or healthcare FSA plans. It also applies to federal COBRA and comparable state continuation. So just because you have a plan that may not be subject to federal COBRA, these provisions may be applicable to your plan nonetheless. As I said, this is a complete COBRA subsidy, so AEIs will pay nothing for COBRA coverage, and then the employer, or in some cases the insurance company, will recoup that cost through a quarterly payroll tax credit. The cost of the premium includes administrative fees, so we know that employers are typically provided or permitted to charge up to 102% of the cost of the coverage to kind of account for that administrative fee. That's the same kind of amount we're talking about here. It's the same amount of the subsidy. It's the same amount for the amount that the employer will be seeking for their tax credit. Just a note here too, if a qualified beneficiary has already paid for months during which the subsidy applies, so if we already have employees that have maybe paid for April or May, we've been given guidance that says that the plan may credit the payment towards a future payment, or they may refund that payment. So what's an assistance eligible individual, or an AEI? An AEI must have lost their group health plan coverage due to a reduction in hours or an involuntary termination of employment for reasons other than gross misconduct. So one of the questions that was asked immediately after this legislation, and I think the DOL guidance provided some additional information, but the reduction in hours does not need to be involuntary. It can be a voluntary reduction in hours. So that's going to include events like change in business hours of operation, changing from full-time or part-time status, a temporary leave of absence, even a lawful labor strike. These are events that are voluntary, but if they result in a loss of coverage because of the reduction in hours, these individuals are still going to be AEIs. The other part of this is they must be a qualified beneficiary under COBRA. That includes typically an employee, the former employee, and their spouse and children. It specifically does not include a domestic partner. And I think the IRS guidance, while not using domestic partners or explicitly stating as such, they've kind of confirmed that that is the correct interpretation. The other part of this is to keep in mind is the subsidy is not available for months after a person becomes eligible for other group health plan coverage or Medicare. So obviously the idea behind the subsidy is that we are providing a coverage to individuals who have no other options to obtain coverage through a group health plan sponsored by an employer. So when that individual does become eligible for another group health plan or Medicare, they're not really in the group of individuals that this relief is attempting to help. So as soon as an individual becomes eligible for a group health plan, they're no longer an AEI. Now, recognize that employers probably don't have a lot of insight or visibility into what their former employees, whether they're eligible through, for example, spouses coverage, or whether they obtain a new job and are eligible for coverage under a new employer. And their previous employer is probably not going to have that visibility. So the way this works is that individuals are incentivized to report that information to their prior employer, or else be potentially subject to these penalties that are listed here. But be aware that other group health plan coverage does not include standalone dental, standalone vision, or other accepted benefits. It does not include QSERAs. It does not include coverage provided through the exchange, medical FSAs, Medicaid, or individual policies. So just because a person is eligible to enroll in coverage through the exchange, for example, or through a healthcare FSA, that doesn't render them no longer an AEI. They still have an AEI and eligible for the subsidy until they're actually eligible for something that meets the group health plan definition. So a key part of this guidance is the second chance individuals, these individuals that have this new election opportunity that ARPA provides them. Well, so who are these people that we're talking about? It's qualified beneficiaries who meet the following 4 criteria. 1, they've lost coverage due to reduction in hours or involuntary termination prior to April 1st, 2021. So we kind of already talked about them, but these individuals have their qualifying event occur before April 1st. Entitled to continue coverage under federal COBRA law, so specifically not state people that are just subject to state continuation coverage plans. It's just federal COBRA. And either did not elect federal COBRA when first offered, or they elected federal COBRA but are no longer enrolled in that coverage and have not exceeded the maximum COBRA period as of April 1st, 2021. So they must elect coverage within 60 days after notice is provided. That's a hard 60-day deadline. The outbreak period extensions, which we all should may be familiar with, that it was a relief last year that basically extended guidelines, various guidelines, some of which are COBRA related, by a year or within 60 days following the end of the pandemic period. I think we are still in. Those extensions do not apply to this 60-day period. Once those notices are received, they have 60 days to make this second chance election. And this is an important concept and one we'll talk about more as we get into the specific IRS guidance. But just to make sure we're kind of understanding the point, well, here's a little illustration, an example. Amy was involuntarily terminated on October 15, 2019, and lost coverage under a plan that was subject only to federal COBRA. If she had elected COBRA coverage, it would have been effective from November 1st, 2019 through April 30th, 2021. So we have an involuntary termination resulting in a loss of coverage in a plan that was subject to federal COBRA. So as long as Amy is not eligible for other group health plan coverage or Medicare on April 1st, 2021, she may enroll in COBRA coverage for free for the month of April 2021. This little illustration of the timeline below. we see that with the qualifying event occurring in 2019, the 18th month maximum COBRA period kind of starts, and it doesn't matter that she wasn't enrolled at any time during that time. She has this second chance election to get back in, even if it's just for the month of April in 2021. So let's change the facts here just a little bit and see how this rule kind of fleshes out. So Amy was involuntarily terminated on April 15, 2018, and lost coverage under a plan that was subject to New York continuation, which provides for a 36-month continuation period. So longer coverage, we have a termination, involuntary termination, resulting in loss of coverage, but it's subject to New York continuation, not federal law. So because Amy is not eligible for federal COBRA, she is not eligible to enroll in COBRA coverage for the month of April 2021. So again, just driving home that point that this second chance election rule applies to federal plans that are covered by federal COBRA law. I think Laura's going to cover the required notices under ARPA.
Yeah, and again, this is a review of things that we knew even before the IRS guidance was issued. So a couple of required notices. The first is the notice to the subsidy eligible individuals who became entitled to elect COBRA prior to April 1, 2021. Those are the second chance electors that David was just talking about. A notice must be given to them regarding the COBRA premium subsidy and their eligibility for it by no later than the end of this month, May 31st, 2021. Those would be for anyone who's actually currently enrolled in COBRA or who fell into that second chance category. The other notice that you need to have on your radar is the modified COBRA election notice for qualified beneficiaries who become entitled to elect COBRA during the subsidy period. So these are what I call kind of the people who are currently becoming eligible for COBRA, right now. And the general timing rules would apply for the timing of the provision of notice to those individuals, and we do not get any extended deadline relief from the outbreak period extended deadlines for giving them the required notification of both their COBRA right and the right to the subsidy. Then we also are required per the DOL guidance to notify persons whose subsidy will expire for reasons other than eligibility for other group health plan coverage at least 15 days before and no more than 45 days prior to the end of that subsidy. So that could be either because their maximum COBRA coverage period is coming to an end. In David's example, that was April 30th, or because the subsidy period is coming to an end, i.e., we're getting close to September 30th. As we've mentioned, the DOL issued model notices on April 7th. While use of the model notices is not required, they do provide, and would be considered to satisfy good faith compliance with the requirements. We're certainly encouraging clients to use the model notices whenever possible. The model notices include some other forms. One is a request for treatment as an assistance eligible individual. And this would be the form that an individual would use to attest to their eligibility for the subsidy. We'll come back to this. Also, a participant notification form. That's the form that qualified beneficiaries would use to notify the employer that they are no longer eligible or are ineligible for the subsidy due to eligibility for other healthcare coverage or Medicare. So one last kind of review item. In terms of the timing, you would provide the COBRA election by May 31st for people who were entitled to elect COBRA before April 1 or within 44 days of the qualifying event. For people who become eligible for COBRA during the subsidy period, there are some different timeframes that apply for plans subject only to state continuation requirements. The employee would complete the request for treatment as an AEI form and return it along with their COBRA elections within 60 days of receiving that notice. And then the plan would be required to provide notice of the expiration of the subsidy at least 45 days, but no less than 15 days before the expiration of the subsidy. And at that point, individuals may have other options for coverage, including possibly HIPAA special enrollment rights, let's say under a spousal plan or their own new employer plan, and may have the option to enroll in a marketplace plan. And that's kind of what that notice is designed to provide individuals with information regarding the notice that's required to be given at least 15 days before the end of the subsidy. So let's move into the IRS guidance and the, what was it, 86 question and answers that we received from them last Tuesday. David?
Thanks, Laura. Yeah, as Laura said, on May 18th, 2021, so a week tomorrow, the IRS issued a breezy 86 Q&As on the ARPA COBRA subsidy. We're, as I kind of implied earlier, we're not going to be able to get to each and every Q&A. A lot of them are highly technical and very specific, and I encourage all of you to read them, of course. Today, what we've tried to do is kind of synthesize the topics that we think impact the most employers and have the greatest impact on the employer obligation kind of piece of this. And those are those key topics right there: eligibility for other coverage, involuntary terminations, calculating and claiming payroll tax credit. Specifically, we're going to throw out that there's guidance relating to plans that are subject to state continuation or coverage requirements only, and that we won't get to. There's details, really detailed Q&As relating to the application to HRAs in coordination with retiree coverage. Those are kind of outside the scope of what we're going to talk about today. Again, if those concepts apply to you or a plan that you work with, then I would encourage you to look at the Q&As. They're very specific and will likely be responsive to any questions that you have out there. So without further ado, our first Q&A kind of here is, this first group of them rather, is going to deal with AEI status, so your status as an assistance eligible individual, and how that interacts with eligibility for other coverage. So as we said at the outset, if you're eligible for another group health plan or Medicare, you're not an assistance eligible individual. So how does that play out when the facts get a little weird? So here's a question: if a potential AEI was eligible for another group health plan, but is not eligible as of April 1st, 2021, are they entitled to the COBRA subsidy? So specific example: an individual's employment is involuntarily terminated, resulting in lost health coverage on October 1st, 2020. On November 1st, 2020, the individual was eligible to enroll in the group health plan provided by the employer of the individual's spouse as part of that group health plan's annual open enrollment period, but the individual did not enroll. So the open enrollment period for the spouse's group health plan ends December 1st, 2020, and the individual has not been permitted since to enroll in coverage. And now we're here to April 1st, 2021. So this individual lost coverage, had a chance the next month to get into his spouse's employer's plan as her beneficiary, elected not to do so. Does that interrupt his status as an AEI? No. The answer here is the individual is not considered eligible for coverage under the plan of the spouse's employer until the first available enrollment period, if any, that begins on or after April 1st, 2021. So we're not looking here at was the individual eligible at any time during this kind of period since they've had their qualifying event. It's really, are they eligible for coverage? We're really looking at April 1st, 2021. Are they able to get other coverage? If they're not, they're going to be an AEI. So the individual may elect COBRA continuation coverage under the plan of the individual's former employer during the ARPA extended election period, and then and may receive the premium assistance as an AEI as well. This little timeline down here kind of shows this. Again, the qualifying event occurring in 2020, we have the 18th month maximum COBRA coverage period that we're kind of monitoring. The individual is eligible for the subsidy from April to September, despite the fact that they had a chance in 2020 to get into their spouse's plan. And I wanted to note too that this would apply similarly to individuals in waiting periods. So if you have a former employer who maybe finds a new job, for example, and is in some kind of measurement period where they can't enroll in the plan, but they might be kind of subject to that plan, as long as they're not able to enroll, they're still going to be able to get that subsidy. So let's change the facts here slightly. What if the spouse's group health plan had an open enrollment period from June 1st to June 14th, 2021, with coverage beginning July 1st, 2021? Well, in that situation, we have an opportunity that is in the COBRA subsidy period for that individual to enroll in his spouse's employer's plan. And therefore, he is no longer an AEI. He is eligible for another group health plan. He is not assistance eligible from that point forward. So looking at the timeline, again, the event occurs in 2020. We have the 18 months. He is eligible to get in April as a subsidy eligible individual, but he is only entitled to the subsidy for April, May, and June. July, he's eligible to get into their plan. So July, August, September, he is not eligible for the subsidy. So kind of going through this concept a little bit further. What if the potential AEI is eligible but does not enroll in another group health plan coverage? Well, similar to kind of what we were just saying, an AEI who is enrolled in COBRA begins employment with a new employer and is eligible to enroll in the employer's group health plan. The AEI declines that. Do we care? Yes, we actually do care now. It doesn't matter if they're in the COBRA period and they're eligible and they don't enroll. They still were eligible. So at that point, their assistance eligible individual status is no longer. Again, one more example just to kind of drive this point home. 2 AEIs who are spouses are enrolled in COBRA. One spouse begins employment with a new employer and is eligible to enroll in the employer's group health plan with self-only or family coverage, with coverage effective the first day of the next month. That spouse enrolls in self-only coverage and the other spouse continues COBRA. Is this person an AEI? Well, although the individual is allowed to continue federal COBRA, the individual is no longer eligible for the subsidy as of the first day of the next month because the individual is eligible for another group health plan. So another important point to underline here, we're talking about the subsidy and a status as an AEI, someone who is entitled to the subsidy. Just because they're no longer entitled to the subsidy does not mean they're not necessarily entitled to continue federal COBRA. So in this situation, although the individual is entitled to continue with their own COBRA coverage, the fact that they were eligible for their spouse's coverage means that they're no longer subsidy eligible. Shifting gears just a little bit, this question is more on the interaction between who is an AEI and disability extensions for COBRA. So the question being, are potential AEIs in a COBRA period disability extension eligible for the subsidy? What's a short answer here? Yes, if the original qualifying event was a reduction in hours or involuntary termination. So what this is confirming is that, you know, we typically think of someone who's had an involuntary termination or a reduction in hours losing coverage as having an 18-month COBRA period. Well, as we know, if you have a disability extension, that can go up to 29 months. So just be aware that you have someone that is currently or that has been on COBRA coverage and is currently on COBRA coverage as of April 1st, 2021. But we know they've been on for, let's say, 28 months. We think, oh, that's a disability event. Doesn't have anything to do with ARPA. Well, it's not necessarily the case. If their original event was involuntary termination or reduction in hours, let's say their 29th month of that coverage would fall in April 2021, that individual would be subsidy eligible provided they've been on COBRA coverage that entire time. I think Laura is going to handle the Q&A on involuntary terminations. Hi, Laura, are you on mute?
Yep, sorry, thank you. One quick reminder before I hop into the discussion of the involuntary versus voluntary termination, because we are getting a number of comments and questions. This slide deck will be emailed to you. If you were registered for this program, it will be emailed to you. We also had a request that we re-email our deck from session 1 as well as the recorded session, and we can certainly include those in the email that we send out following this presentation. So that will all be available to you through an email. The Q&As, we were really hoping that the questions and answers issued by the IRS would give us really good, clear guidance and understanding around how to make a determination about whether somebody's termination of employment was involuntary. And unfortunately, I think the guidance fell short. You know, the language here, what is an involuntary termination? The answer is straight out of the Q&As. It's a severance from employment due to the independent exercise of the unilateral authority of the employer to terminate the employment of the individual other than due to the employee's implicit or explicit request where the employee was willing and able to continue performing services. What we, you know, learn from more Q&As, there's 11 specific Q&As on the question of what is a voluntary versus involuntary termination, is it's a very facts and circumstances type of analysis. You know, it depends is often the answer to the question, was this an involuntary termination? I do want to remind folks that it is crystal clear that involuntary termination includes terminations for cause. So if you terminate somebody for performance reasons, you terminate somebody for excessive tardiness, you terminate someone for violation of company policy, assuming that does not rise to the level of gross misconduct, and I don't want to get in the weeds of what constitutes gross misconduct, but I will say that the bar is extremely high for gross misconduct. And it's not going to be those three things that I just said, then that is an involuntary termination that would make somebody eligible for this subsidy. This kind of surprised some people because I think people were thinking, rightly so, that the reason for this legislation was to help people who had been impacted by COVID and who had been impacted by a downturn in business and economic conditions due to COVID. And it's hard to, you know, see how that relates to somebody being terminated for, you know, repeated poor performance or repeated tardiness or, you know, whatever. But unfortunately, you know, the law painted with a broad brush and just said any involuntary termination and didn't, you know, tie it back to COVID. A couple of things that through the questions and answers, we could constitute voluntary terminations, that might seem like voluntary terminations, but actually may be considered involuntary for purposes of determining a person's eligibility for the subsidy. So terminations for good reason that result from a material negative change in an employee's employment that was initiated by the employer. So the employer requiring that the employee change the location at which they work or perform services. The employer failing to provide a reasonable accommodation. The employer reducing a person's hours, which then leads that person to terminating, you know, his or her employment, might constitute a material negative change that would turn that from what you might otherwise characterize as a voluntary termination to an involuntary termination. Some items that would have been characterized as voluntary resignation or retirement. I'm back on the other slide. Could be considered involuntary if that individual was going to be terminated by the employer anyway, you know, had they not retired or voluntarily resigned. Again, this is a very facts and circumstances determination. Part of it is going to hinge on whether the employee knew that they were getting ready to be laid off. Individuals who terminate from work due to illness or termination of individuals who are absent from work due to illness or disability could be considered involuntary if there was a reasonable expectation that the employee would return to work after the illness or disability had they not been terminated. Severance in connection with a window program where for employees with, quote, impending terminations. So this could bring in folks that were terminated as part of some type of voluntary reduction in force. All of these, if you've had any of these types of actions within your workforce, I think they all need to be carefully analyzed in the context of the Q&A guidance, coupled with the facts and circumstances of your particular situation.
All right. The next Q&A that we're going to discuss has to do with the extended election period. We talked about these second chance individuals at the beginning of the presentation, and we received some more guidance on kind of what those elections look like and some other things to consider. So our first question on this, what is the COBRA effective date for second chance individuals? Well, it's really three different options. AEIs with a qualifying event occurring before April 1st may elect to begin COBRA coverage either retroactively to the qualifying event if they're still in their election period, including the extended election period from the emergency relief notices that we talked about, retroactively to April 1st, 2021, or prospectively from the date of election. So, for example, if I receive my notice on May 31st and I'm in June 1st, I can elect to just go June 1st forward, or I can go back to April 1st, or if the retroactively in my qualifying event, whatever that was. So here's an example. An individual is involuntarily terminated from employment on December 15, 2020, and receives the COBRA election notice on January 4th, 2021. As of April 1st, 2021, the individual has not elected COBRA. Again, the individual has these three kind of options: retroactive to their qualifying event, starting effective April 1st for the COBRA subsidy period, or prospectively from the date of their election. So we have these individuals that are in this weird second chance window where they can either go back and get coverage at the beginning because there's this other extension guidance out there, and we have this new extended period through ARPA. And how do those interact? Well, one of the questions that comes up as a result of that is, does owing premium payments for retroactive coverage impact COBRA subsidy eligibility? The short answer is no. If you have premium payments due that you have not paid, it really doesn't impact your COBRA coverage from April 1st to September. So let's look at an illustration to kind of nail that point down. On November 1st, 2020, an individual becomes a qualified beneficiary as a result of an involuntary termination of employment and receives the COBRA election notice. On April 30th, 2021, the individual receives the notice of the ARPA extended election period. On May 31st, 2021, the individual elects both retroactive COBRA coverage beginning on November 1st, 2020, and 2, COBRA coverage with premium assistance for the first period of coverage beginning on or after April 1st, 2021. But the individual pays premiums for only 3 months of retroactive COBRA coverage within the applicable payment deadlines. So we have an individual who has this second chance election. They elect to start back retroactively from their qualifying event, starting off in November 2020. They make payments for November, December, January, and no longer make payments. Well, does that mean that I still have to offer them 100% subsidized coverage from April, May, June, July, August, September? Yes, you do. The IRS guidance that came out says the plan has to treat the individual as having retroactive COBRA coverage for the months that they paid their premium, so November 2020, December 2020, and January 2021, and having no retroactive coverage, so like a gap, February and March, because they didn't pay premiums for that retroactive coverage. But because the individual also elected COBRA coverage with the premium assistance for the first period of coverage beginning on or after April 1st, 2021, the individual has that coverage effective April 1st, and it's subsidized through September 30th, 2021. So it's something to keep in mind as we see whether or not individuals will be electing retroactive coverage. And it's something that really, even if they don't make their payments for retroactive coverage, we still have to be making sure that they're getting the subsidy if they're otherwise entitled to from April to September. So here's one of the more, in my opinion, surprising pieces to come out of the IRS's guidance, and it's employer friendly, so that'll be welcome news to many. The question: may AEIs who decline retroactive coverage when claiming subsidy later claim retroactive continuation coverage? The IRS guidance says no. Individuals who elect coverage for the COBRA subsidy period but decline retroactive COBRA continuation coverage before April 1st, 2021 may not, after the 60-day extended election period, later elect retroactive COBRA continuation coverage that begins at the time of the qualifying event. So in other words, the election begin the coverage as of April 1st, or prospectively from your receipt of notice forfeits your right to go back and your extended election period under the prior relief for retroactive coverage. So let's look at an example to really illustrate that. Andy was involuntarily terminated on March 1st, 2021, and receives a COBRA election notice that day. Andy receives notice of the ARPA extended election period on May 31st, 2021, and elects COBRA continuation coverage with premium assistance starting April 1st, 2021. So his 60-day period starts May 31st, effective July 31st, so 60 days following that notice. He has June and July, and he actually forfeits his ability to later elect COBRA continuation coverage retroactive to March 1st, 2021. Remember, under the prior relief that we had last year, it would have extended his ability to elect COBRA coverage from the sooner of the expiration of the pandemic or a year. So this is really kind of an interesting twist that if we send notice to these individuals, they have 60 days to elect, and if they elect COBRA coverage that starts either April 1st or prospectively, they cannot go back and get that retroactive cover, any retroactive coverage for whatever period, in between their qualifying event and April 1st. So again, the image below kind of is supposed to show that March coverage is forfeited. And Laura, I think, is going to handle the tax credit information.
Yeah, and before I get there, I'm going to answer some quick questions that have come in that kind of relate to the whole involuntary versus voluntary versus reduction in hours. So real quick hit items. Actually, this isn't even one of the questions that was submitted, but the Q&As did confirm that if the individual's COBRA qualifying event is death of the employee, for example, which can trigger COBRA rights on behalf of a surviving spouse and covered dependents, that is not considered an involuntary termination of employment. Those folks are not eligible for the subsidy. There was a question about what about divorce? What happens if divorce triggers COBRA eligibility? Not eligible for the subsidy. Again, doesn't mean they're eligible for COBRA. This doesn't in any way alter the normal COBRA rights that people have and when they have them, but they don't get their coverage subsidized, just in the event that the event was divorce. Dependents aging out of a plan, no subsidy available to dependents who age out of a plan. Also had a question about the reduction in hours and what if an employee voluntarily reduces their hours? Just no reason initiated by the employer, just the employee comes to the employer and says, I got to go from full-time to part-time. That results in a loss of coverage. That is subsidy eligible. So the reduction in hours doesn't have the word involuntary in front of it. So it's either an involuntary or voluntary reduction in hours. If that triggers the COBRA coverage, that person and all associated qualified beneficiaries would be eligible for the subsidy. So a lot of kind of quick hit items there around that topic. So on the tax credit, and this was really, another part of the guidance that we were waiting on. Of course, the DOL is not going to talk about tax credits and how you take them. That's going to come from the IRS. And this is really one of the reasons why you do need to be careful about your administration of these provisions, because on the one hand, you may be thinking to yourself, well, I'm just going to always, make determinations in favor of the participant. That, seems to be, the nice thing to do, the right thing to do. How can I get in trouble if that's what I do? Well, how you can get in trouble is if, you administer this in a way that isn't consistent with these rules and you take the corresponding tax credit, you've just now taken a tax credit that you weren't entitled to take. Or more of a tax credit than you were entitled to take. So you do have to be very cautious and careful here because we are talking about tax credits. And so just a couple of things to understand, as David alluded to at the beginning, the tax credit will include not only the full premium or premium equivalent cost or COBRA premium that person would have otherwise paid, but also that 2% additional charge that's designed to cover administrative costs. You will be able to get a tax credit for that piece of it. You can only take the tax credit for a COBRA premium either for the same coverage or similar coverage or a lower cost coverage option. This is not an opportunity for people to, you know, buy up or move up in terms of the you know, type of plan, a richer plan, and therefore enrich the tax credit. If the employer, if as an employer you are voluntarily subsidizing the cost of COBRA coverage as part of some type of severance plan or program or policy, then the tax credit is not available with respect to that portion that you were already voluntarily offering to individuals. And this is a really key point because it's not as simple as saying, well, we'll design our plan to say that if you're eligible for the ARPA subsidy, you know, you're not eligible for our subsidy, but for anyone who isn't eligible for the ARPA subsidy, we will provide, you know, kind of a voluntary subsidy. Doesn't work that way. The IRS guidance is crystal clear that if you provide a subsidy to anybody, whether they're ARPA subsidy eligible or not, you're not going to be able to take a tax credit for that portion that you were willing to voluntarily provide to your employees. So, you know, you really have to think carefully about this. Maybe you want to think about amending your severance plans or programs. I mean, certainly you could do that on a prospective basis. It's going to be, I don't think you really could do it, or you get yourself in trouble if you try to do it on a retroactive basis. And then you have to wrestle with, is it worth changing our plans for this sort of remaining 3 or 4 month period in which we're dealing with this ARPA subsidy, because that the whole thing's going to go away, you know, at the end of September. And then again, as David mentioned, the credit is only available with respect to the cost of coverage for otherwise qualified beneficiaries. So this means that if you are going to provide the subsidy to domestic partners, you certainly can do that. You know, that's being more gratuitous than you're legally required, but you're not going to be able to take the tax credit. And there are some very detailed rules that describe how you are supposed to allocate the cost of coverage between, you know, actual qualified beneficiaries and other beneficiaries that are being offered the subsidy. So if you have that, you will want to, you know, review those rules very carefully. Who gets to claim the tax credit? It's the employer if the group health plan is subject to federal COBRA, and this applies whether the plan is fully insured or self-insured. And so it's really important that employers of fully insured plans understand, you know, the individuals are not going to be paying the premiums. You will need to pay the premiums for that coverage to the insurance carrier, and then turn around and take the tax credit on your payroll taxes. It's the insurer that takes the tax credit if the group health plan is subject to state but not federal continuation COBRA requirements. So this would be for smaller plans that are fully insured. And then multi-employer plans, which are union-sponsored plans, it's the multi-employer plan that includes the tax credit. When is the tax credit available? So it's claimed, it can be claimed as of the date the eligible individual's election is received for periods of coverage that began before that date. For subsequent periods, the credit is available as of the first day of the period of coverage. So if your period of coverage is monthly, you know, the July credit, the credit for July premiums is available to be taken as of July 1. So an example, let's say on June 17th, 2021, an eligible individual submits an election. The employer may take a tax credit for the cost of coverage for April, May, and June, because those are all the periods of coverage that started before you received the election. And then assuming the employer is not notified that the eligible individual is no longer eligible for the subsidy, let's say because they become eligible for other group health plan coverage, it can take a credit for July as of July 1, for August as of August 1, for September as of September 1. And this all ties back to, you know, the timing of when you apply for the tax credit through your payroll function, which leads me to the next page. It's the form 941 that will be used to take the tax credit. There's also an ability to request an advance for the anticipated tax credit, and I think also the ability to get a refund if you don't have enough employment taxes to cover the amount of the tax credit. The final thing that I think is really important to understand is that the substantiation requirements. So individuals, the guidance states that individuals are permitted to self-certify or attest to their eligibility status with respect to involuntary termination or reduction in hours. You know, this is kind of interesting. You may say, well, what do you mean? I mean, we know whether they were involuntarily terminated or had a reduction in hours. Why would we, you know, need them or want them to self-certify? Some employers, I think, did not track this information. I mean, I think it was pretty clear when we were working with companies that employers were not used to tracking this level of detail. And certainly, they're not going to be tracking it for some of the more nuanced situations that I talked about in this program, where, you know, you might have thought, well, I thought that was voluntary, and based on the facts and circumstances, it turns out maybe it's involuntary. So, you know, this is permitted, and you'll need to be thinking about how you handle situations in which an individual may, you know, try to certify that they were eligible due to involuntary termination or reduction in hours, and yet maybe your records don't seem to indicate that. And you may need to put in place a process whereby those cases are reviewed on, you know, an escalated basis or a case-by-case basis. Individuals are also permitted, the guidance says, to self-certify or attest to their eligibility status regarding the absence of other disqualifying group health plan coverage or Medicare. I'm glad to see this because I don't know how someone could possibly otherwise, you know, prove a negative. I mean, that's hard to do. So you'll just want them to be certifying to that. Employers can rely on self-certification unless they have actual knowledge that the certification is incorrect. But the key here is the last bullet. Employers are required to keep a record of the attestation or other documentation in order to substantiate eligibility for the tax credit. And this is an item that really was not fleshed out with much more detail than what's stated here in the IRS guidance. So, you know, it's a tax credit. I think we can expect that the IRS is, you know, potentially going to, you know, after the fact, audit employers, possibly ask for information or supporting documentation for the tax credit taken. This is going to be, you know, months from now, probably next year, after all the tax credits have been taken. And you need to be thinking through what kind of information or documentation would I present to an IRS, you know, auditor or, you know, in response to a request for such information. A lot of COBRA administrators are doing a paperless type of transaction here. They're just accepting phone calls from participants. Sure, they have a call log. I don't know how long the call log is being, you know, maintained, but some COBRA administrators are doing kind of an opt-out. So they're just automatically assuming that they're eligible if they're currently enrolled in COBRA and if the records indicate an involuntary termination or reduction in hours, unless the participant tells them that they aren't eligible. You know, query whether that will create sufficient documentation to support the tax credit taken.
Hey, Laura, just to jump in, because we have a question that's exactly on this topic, and the question is, if the employer takes the lenient eligibility approach, how is the tax credit eligibility based on the employee's attestation? And I think you're hitting all the notes, but just wanted to highlight that, and if there's any more considerations as we, I don't know, kind of try to beef up our documentation in the event, or anticipating the event of audit.
Yeah, I mean, there's definitely, it's a push-pull kind of situation here. You know, on the one hand, the IRS is telling you you can rely on self-certification, which seems to be a very participant-friendly type of mode. The flip side of that is they are going to want you to have substantiation for the tax credit. I think probably the way I would reconcile those two things is, at a minimum, I would feel most comfortable with a piece of paper on which the employee has checked some boxes, or former employee, and signed their name and sent it in. Now you have a piece of paper where the employee is saying, yep, I was involuntarily termed or reduced hours. Yep, I'm not eligible for group health plan coverage. I'm signing here and I'm sending this form to you. And then you present those forms if you were asked for the substantiation. I'm not so sure that, that's actually what's contemplated by all COBRA administrators out there right now. And in fairness, I think it's not contemplated because that's a lot of paperwork, and that's putting the burden on the employee to, print something out and scan it and email it, which, sometimes is difficult right now.
Yeah, I think as you kind of alluded to, this is going to be a pressure point, because on one hand you have the involuntary termination analysis, and we have a question that was essentially, do we need to dig into all the details of each individual's circumstances relating through to covered, or for termination through other people's coverage? So there's this obligation for employers to inform themselves. You also want to be generous, for example, in the involuntary termination context, you don't want to exclude anyone that may be considered to be an involuntary termination. But on the other hand, you do need to have substantiation in case someone asks why this person has a subsidy, in order for you to recoup that tax credit. So it is going to be a pressure point, and something that I think the employers are going to have to develop an approach that they're comfortable with.
Want to take the last slide here?
Yeah, we'll take the next steps, and then we'll go back to Q&As, because we have quite a few. So next steps and issues to consider. Identify, of course, if you haven't started already, we hope you have, to identify your former employees who have lost health coverage due to an involuntary termination or reduction in hours. As we've kind of been assisting employers do this, it's become very clear that an analysis needs to be done to evaluate whether your codes that say termination align with the IRS guidance. Kind of going back to that point, you may have codes that are as simple as involuntary termination and voluntary termination, and think, oh, well, everyone that's under a voluntary is voluntary, so they're not going to be an AEI. But as Laura talked about, it's really, it depends on the facts and circumstances. And if you have individuals that are being coded as voluntary termination who maybe resigned as some part of kind of severance incentive that occurred last year, those people for these purposes really should be considered involuntary. So looking at your codes, making sure that they're in line with the IRS guidance, so you're capturing all the people you need to. Also consider how far to look back. Again, the second chance individuals is one thing, but we also talked about people that are currently on COBRA coverage, but who have been on for longer than you might have anticipated due to a second qualifying event or disability. Just make sure these things are being thought about, so the entire kind of population that's impacted by ARPA's COBRA subsidy provisions are accounted for. And the second bullet there, coordinate with COBRA vendor regarding notices and implementation of subsidy assistance. Notices are due May 31st. That is 1 week from today. I just had to double check, but we hope that you've been engaging with your COBRA vendor before today, and that those are ready to go out if they haven't gone out already. Third bullet, coordinate with payroll regarding calculation of and process for claiming tax credit. Again, this is already a cost to employers, and making sure that you're able to recoup some of that cost via the tax credit is vital. So make sure you're engaging with the right parties and processing those claims for tax credits on a timely basis. Last bullet there, confirm with COBRA vendors details regarding documentation, certifications that will be available and will be retained to substantiate the tax credit. So what we were just talking about, make sure your COBRA vendor has some kind of methodology for recording these elections. In an ideal world, as Laura said, paper would be great. Some kind of electronic attestation or certification would be great. When we start getting the phone calls or things like that, making sure that there's actually a log of those things, so in the event that there is an audit in the future, that we can go back and say, yes, we were relying on this. We don't have knowledge to the contrary of this. we've done what we're supposed to do. And then lastly, some issues to consider. Just think about whether to amend your severance plans, revise severance agreements to reduce or eliminate company provided subsidies. Again, it would have been nice to have this specifically indicated prior to April. It's a little difficult now to change severance that has been promised for April and May, but we have September till September, so it may be worth it to take a look at that and see if any voluntary subsidy should be removed, so you're increasing your COBRA costs, so you're able to increase what subsidy you're able to take, things of that nature. And lastly, consider potential impact on claims experience. I think this will lead to an increase of claims almost certainly, so just be aware of that and be prepared. So with that, I think we'll start going back to some Q&As. Laura, did you have any that were...
Again, I'll just say that we will send an email. Another good suggestion was to send a link to the Q&As in the email that we send. We'll do that. We'll link the IRS Q&As. We'll link this presentation, the deck from session 1, the recording from session 1, and the recording from session 2. So you'll have all this information at your fingertips, sent to you in an email within the next couple of days. The recording takes a little longer, so maybe we'll get one batch out right away and then follow up with the recording. There are some questions, and David, I might direct these to you, just asking around dental vision and is it just medical or is it also dental vision? Do you want to just kind of reiterate those rules?
Yeah, absolutely. And I think there's two components of this. How we have some clarification on dental and vision only. So the first part of it is that what does this apply to? Group health plans. Well, does that include dental only and vision only plans? It certainly does. So the COBRA subsidy provisions would apply to those plans in that context. The other component of this is, am I eligible for another group health plan when considering if I'm an assistance eligible individual? So I am not an AEI if I am eligible for another group health plan. But as we talked about, in that context, that does not include a dental only or vision only plan. So I can be eligible for a dental only plan, hypothetically, through my spouse's employer. I've lost medical coverage from my previous employer. I still don't have medical coverage. I have, dental or vision only. But the COBRA subsidy, the whole point of this is to, help people that have been impacted by COVID and make sure that they have health care. So that would be the two sides of that. I think on one side, it's definitely, subject to the rules. But if on the other side, it does not count as a group health plan to, disrupt your otherwise being eligible as an AEI. Hopefully I answered that.
Yeah, it is causing a lot of confusion, but there is a question in here about what do I tell the former employee their COBRA will cost if our plan has increased since they left the company? We only have one plan option. Do I just use the current pricing? Yeah, in that case, if you only have one option, and it happens to be more expensive than the option that the person had when they had their qualifying event, let's say sometime last year, it's the one option that you have now that would dictate, what they're eligible for and what the cost would be. Of course, you say, what do I tell them the cost will be? Well, if they're eligible for the subsidy, the cost is going to be zero, at least through September 30. And then if they, they still have more time in their COBRA period, it will be the premium cost of that one option. And likewise, your tax credit, can correspond with the cost of that coverage in that case, even though it's more expensive than the one that was offered when the person had their qualifying event.
Yeah, and I would just add to that, at the risk of, in this circumstance, it was a one plan, so it's a little different. If for some reason there was a plan shift and there was other options, we have received the question of, well, can we just default them into a more expensive, whatever the more expensive option is, and then take the whole, or take the tax credit for only what their prior coverage is. there's a specific Q&A in the IRS guidance that says, no, you can't do that. It's, you know, the only time, if you have more expensive coverage, none of it is COBRA eligible unless it's the circumstance that Laura was just discussing. It's the most similar plan to what they had prior, and the prior plan is no longer available.
Yeah. I'm seeing another question that talks about, what if the employee was involuntarily terminated, but the employee is eligible for Medicare, but the employee's dependents and or spouse is not eligible for Medicare? Certainly, you know, a very possible scenario. I think you just have to remember that each COBRA qualified beneficiary sort of has an independent and separate right. So while the employee, if they're eligible for Medicare, depending on maybe, you know, when they became eligible, is not eligible for the subsidy, that does not mean that other COBRA qualified beneficiaries associated with that employee, like a spouse or dependents, is not eligible for the subsidy. They would be eligible for the subsidy, assuming they don't have, you know, other group health plan options available to them.
Yeah, and there's a similar question with Medicare, and they're seemingly asking, it says otherwise qualified person eligible for Medicare, but only eligible for COBRA for dental insurance, which Medicare doesn't cover. Does a person qualify for COBRA subsidy for the dental insurance? So yeah, this is an interesting question. And I think, and Laura, let me know if you disagree, but I think the way that it's written is that if you're an AEI and you're eligible for a group health plan or Medicare, or you're not an AEI if you are eligible for another group health plan or Medicare. So if I'm reading this correctly, this person is eligible for Medicare. Dental is not covered by Medicare. I mean, they would not be an assistance eligible individual. A different result would be if they were in a dental standalone plan. Actually, potentially, I think my answer would still say the same. I don't think the IRS guidance changed the reading of the original statute, which is if you are eligible for a group health plan or eligible for Medicare, you're not an AEI, so you wouldn't be subsidy eligible for the dental portion either. I don't know, Laura, if you had any thoughts on that one.
I agree with you. I'm glad you stopped, because I was going to say, I don't know. No, I agree with your answer.
Yeah, the fun exercise of the Q&A is that they're all very high fact specific. So, you know, you have to talk it through and then you get to the answer here.
Let's see, another question. Our plan only provides for coverage if the employee elects coverage. So we need to amend the plan to allow dependent coverage even if employee does not elect it. I'm not 100% sure that I fully understand that question. If you mean your plan only allows COBRA continuation coverage if the employee elects COBRA continuation coverage, I think you may need to revisit that plan design, because you know, it's, as I said, each COBRA qualified beneficiary has their own, you know, separate right, and it's not contingent, for example, on whether the employee elects COBRA coverage. A covered spouse could elect it without the employee electing it. Of course, if you don't offer group health coverage to anyone other than employees, so you have no ability for an employee to enroll a spouse or dependents, then those folks would never have a COBRA right. You know, they never had coverage to begin with, so they don't have a COBRA right. So I don't know if that answered the question, but it's probably as far as we can go on it.
Yeah, I think that it was you've covered both interpretations of that question. Another question, if their COBRA period was to end May 5th, 2021, are they only qualified for the month of April and up till May 5th? So if they had meaning that their expiration of their maximum COBRA period would expire on May 5th, that gets into the period of coverage question, I think, Laura, that we've discussed, but I will just answer it yes in that way. If their COBRA period has been exhausted, then their subsidy period is also exhausted. The subsidy does nothing to extend someone's COBRA maximum COBRA period. put it that way.
Yep.
Another couple quick hitters. What if the employer retires within this subsidy? Well, again, use the word retire. That would go to the involuntary termination discussion we had. If it's a true retirement, then I think it's a voluntary termination, and it's not implicated by this. If it's some kind of incentivized retirement or retirement in anticipation of being laid off, we may have an involuntary termination. And if that's the case, if someone has a qualifying event during the COBRA subsidy period, then they're absolutely eligible for the subsidy, assuming everything else is qualifying for an AEI status. Here's a question, I think, on timing of payment. Can an employer pay for 6 months of COBRA going forward, say June 1st to December 1st, or does it need to retro pay back to April 1st? I think what this is getting at is if the individual has already, maybe that's not it. I was thinking maybe it's getting at if the individual has already paid for coverage in April and May, in which case an employer can refund that amount, or they can apply it towards future premium amounts. Otherwise, I'm not sure. I'm exactly sure what the question is asking.
Yeah, I saw that. I wasn't sure either. I mean, it is, I wasn't sure if it was getting at something that we talked about, which is an employee can say, I want to opt into this subsidized coverage effective on a prospective basis. So it doesn't have to go all the way back to April 1. They could say, I want to elect this effective July 1. And maybe the reason they're saying that is because prior to July 1, they had other group health coverage, but effective July 1, they're losing it for some reason. But otherwise, I'm not sure what this question is.
We got confirmation that was what the questioner was asking, so I think we've addressed it. I think we've already discussed the aging out issue.
Yeah, an employee. We've addressed most of the questions.
Yeah, one thing that you mentioned earlier that I guess I wanted to, if we had time, add to, because I've gotten questions on this as well. You had mentioned that if a death is not a qualifying of, well, death is not an involuntary termination for these purposes. So someone who dies is not, their beneficiaries may not be entitled to a subsidy under these provisions. There was a specific Q&A in the IRS guidance that was released last week that says, if someone who has an involuntary termination or reduction in hours, and they and their spouse or dependent children are covered under the subsidy, their subsidies are actually not going to be terminated in the event the individual dies during the subsidy period. So, and it's obviously a distinct issue. It's the qualifying event was the voluntary or involuntary termination or reduction in hours, but if they subsequently die, they're not going to terminate the subsidy at that point. So that was just one little additional nugget there.
Mm-hmm.
But otherwise, I think we've addressed the most of the questions.
I'll mention one more detail in the same vein of the involuntary term. There is a specific question and answer about whether a decision not to renew an employee's contract is an involuntary termination of employment or not. And I without going into the weeds in the interest of time, if you have those scenarios where you have people that are hired for, very discrete periods of time, maybe under a contract, you need to look at Q&A 34, because it's one of these, it depends. And, based on some facts and circumstances, that might be considered involuntary, and under other facts and circumstances, it would be considered voluntary. Basically, it's going to be considered voluntary if the parties understood at the time they entered into the contract and at all times during which the services were being performed that the contract was for specified services over a set term and would not be renewed, then that's not considered involuntary. But you can see that it's going to be easy for an individual to sort of argue, well, even if I thought that at the beginning, I was doing a great job and kept getting positive feedback, and I just assumed that, my contract would be renewed, and then boom, it didn't get renewed. That could like sort of turn it into an involuntary termination, or arguably an involuntary termination. So again, a very facts and circumstances type of determination.
Yeah, and a good reminder to the point you made earlier. These are conversations to have with your COBRA vendor to make sure the appropriate claims are getting escalated, so these decisions can be made on a at the employer level, because there's just not a one size fits all for these kind of situations. So.
Yep. So I guess with that, I just want to thank everyone for joining us today. Certainly, if you have any other questions after today's program, feel free to reach out to your regular Thompson Hine attorney, or if you don't have one, feel free to contact either David or myself. Thank you very much, and I hope you enjoy the rest of your day.